rise for the District State of Florida now session. David Monaco, Chief Judge, presiding. All right, saying this is for the sport trial. May God save the United States of America. Florida and this honorable court. Please be seated.
Well, good morning and welcome to a session of the 5th District Court of Appeal. Let me introduce the panel. To my right is Judge William D. Palmer. To my left is C. Allen Lawson. We have 4 civil cases scheduled today. Each side will be permitted 20 minutes. If you wish to, if the appellant wishes to reserve some time for rebuttal, let me know how much you want. I'll feed it into the clock. It'll start flashing up there for you, and then I'll try to give you a hand signal at the same time. We're going to have a change of panels at for the third case, Leah Britt versus Bank of America. And in order to accommodate that, what we're going to do is to move that to the last case. What we will do then is take a break at the end of the third case and maybe get some coffee in the lawyer's lounge, and then the new panel will hear the final case. All right, one last thing, and that is if anybody has a cell phone or other device that has an on-off switch, out of courtesy to those arguing, would you please turn it to the stun or off position. Let's begin with the first case, Shaun Richard English versus TRACY LARUE MAYER. And as I understand it, the appellee is not permitted to argue in this case because there was no brief filed.
Yes, may it please the court. I'm Michael Boswell, and I have with me as co-counsel Jennifer Schulte, both of Advocates Legal Clinic, representing the appellant Shaun English, who is in the gallery. Your Honors, as the recently deceased second DCA Court Justice John Shebb taught it in his appeals class at Stetson, the purpose of oral argument is not merely to re-argue one's brief. The court has already read your brief and is busy enough without hearing you regurgitate it. Equally, in a case that has been fully briefed, oral argument may not be necessary. In this instance, this case is not fully briefed. There was not an answer brief that was filed, and as such we were unable to file a reply brief. And so we avail ourselves of the opportunity to be able to respond to the court's questions that might have been addressed in the answer brief and which we would have responded to in the reply brief.
Well, now you've thoroughly confused me. What exactly are you going to do? There are cases that were not cited within our initial brief, which we believed when we filed our initial brief were distinguishable. And so I'm here to present to the court why we believe those cases are distinguishable. And
well, I have a question. The thrust of your argument appears to be that the trial judge reversibly erred by not permitting you to put on the testimony that would establish jurisdiction. And as I read the transcript, the lawyer below indicated that he did not want to put on any testimony or proffer any testimony at this time during the hearing. And then the trial judge gave an open opportunity, is there anything else that you want to present? And the attorney said no. So I fail to see how that issue is preserved for review. I mean, it appears that the trial judge made no mistake, didn't bar you from presenting anything, allowed you to present anything you wanted, and for whatever reason the decision was made not to present evidence. So how is that an issue that we can look at when it was a decision made by your client's attorney at the time not to present evidence?
Well, the case below, this case arises from a motion to dismiss which was initially issued sua sponte by the lower court. And so within the motion to dismiss, we're looking at the 4 corners of the pleadings and not having an evidentiary hearing. So the hearing...
Well, then how was there... I'm just having a hard time following you, because your first point is that we should have been allowed to present evidence at the hearing.
Well, we should have been allowed to have had a hearing where we presented evidence because there were clearly facts in dispute at the motion to dismiss hearing, which would have prevented the judge the court below from dismissing the case without leave to amend to be able to address either if the lower court was going to properly stay within the four corners of the motion to dismiss within the pleadings, then it would have been more appropriate once it was presented that there were facts that were in dispute relative to the issues, to then have granted a motion to dismiss with leave to amend to be able to address those factual disputes.
The allegation was that the child had been in Florida for less than 6 months and was no longer in Florida, correct?
No. The allegation was our allegation was that to our knowledge, when the couple attempted to reconcile, that the child had been in Florida for less than 6 months, but there was a letter within the domestic violence case of which the lower court took
that was never brought to the attention of the trial judge, correct?
That was not brought to the attention of the trial judge.
So all the trial judge had was your complaint, which said that the child had been in Florida for less than 6 months, and nothing else was brought to his attention, correct?
No. What equally brought to her attention was that in the domestic violence case that the mother had filed a UCCJEA form indicating that in the domestic violence case that in her UCCJEA form that Florida was the that Florida was the home state for UCCJEA purposes. So
That was a domestic violence claim.
that was a domestic violence claim, but which Judge McKinnon determined was a specious claim and ultimately found the mother in contempt twice, and in fact that case continues to today. It continues to be open.
Did you ever ask for a hearing?
We asked specifically.
When and where?
We asked at the hearing specifically that relative to the other statutory provisions of the UCCJEA, that the judge stay her ruling and confer with the state of Louisiana court to be able to determine whether or not there was any ongoing proceeding within the court in Louisiana, so that in addition to the 6-month bright line rule, she might then be able to continue to proceed under the other rules which would grant her subject matter jurisdiction in this matter. For instance, at that point in time, it was presented at the hearing that the mother no longer lived in Louisiana, and that whenever she fled the state that she went to Arkansas, and that whenever Judge McKinnon ordered her to return to Florida with the child, that she returned to Florida with the child from Arkansas, and that no one resided in Louisiana at the time of the hearing. So but to give a more succinct answer to Judge Palmer's question, at the time, pardon?
That's Judge Lawson.
Okay, I'm sorry.
Does it say Palmer up
It says
Does it
Palmer
say
in
Palmer
front
up
of me. It does.
Okay.
I apologize.
Does it say Monaco up here?
It does.
Okay.
Well, you and I know each other well. In fact, I cited ST to someone this week. It continues to be good law. So at the time of that hearing, all of the parties were in Florida, and the mother and the child was in Florida pursuant to court order. So no, at the time of the hearing, the mother and the child were not elsewhere. Equally presented at the hearing.
Well, I'm still confused, if you will, Mr. Boswell. What
Okay.
about the request for a hearing? Because when I read through the materials, I didn't see an outright request for a hearing. I saw a request to consult with the judge in Louisiana, but I didn't see anything beyond that. Do you have a page reference, a record reference, where I can look at that?
Where we specifically requested an evidentiary hearing?
Yeah.
I do not.
Perhaps Ms. Schulte can help us out on that.
Well, I have the transcript.
Oh, well,
so.
give it to her, maybe she can.
Okay. I didn't want to take the court's time and my time to fumble around looking
Now, a
for it.
motion to dismiss for jurisdictional grounds is not necessarily confined to the four corners of the complaint, like a motion to dismiss for failure to state a cause of action, right?
Yes.
So,
In this instance, when she determined that, when she heard that there were conflicting evidentiary issues, for instance, the mother had then and continues to have now a Florida driver's license since 2006, that the mother had completed a UCCJEA form in the domestic violence case, identifying Florida as the home rule state. She could have then
taken evidence, which she offered to let you do, right? And you didn't do it.
and the hearing was styled as a motion to dismiss hearing.
But a motion to dismiss for jurisdictional grounds, which can be evidentiary, right?
Can be evidentiary.
Didn't say on the notice this is a non-evidentiary hearing. It didn't say you couldn't present evidence, correct?
Correct.
And at the time of the hearing, the judge said, you got any evidence you want to present?
Well,
That was, why wasn't that your opportunity? And if you thought you had evidence to present, why wasn't that the time to do it?
well, and in fact, we believe that we did present sufficient evidence to create a dispute of fact, which would then overcome.
This isn't a summary judgment. We're not talking about whether there's a disputed fact. This is a motion from jurisdiction where the trial court is looking at deciding the ultimate fact. Creating an issue of fact isn't important on a motion to dismiss. It's proving up whether or not there's jurisdiction, right?
Yes, and in fact, we believe that sufficient evidence was presented, that evidence was presented at that hearing, which would have overcome a standard for a motion to dismiss.
So are you abandoning your argument that you think you're entitled to another evidentiary hearing? Because you've now said you presented enough evidence.
I said we presented some evidence. I don't know.
No, you said you presented sufficient evidence.
We requested that she take judicial notice of the domestic violence file, within which there was a letter from her father stating that she had been there for 8 months. I believe
And
that...
showing that you go beyond the four corners of the complaint, right?
Yes, and so I believe that the more appropriate thing for her to have done, based upon the demonstrated conflict of facts, would have been to either allow us to have a full and complete evidentiary hearing.
Well, she did. She allowed you to have a full and complete evidentiary hearing. She said, do you want to put anything else on the record? And you said no. Okay. How much more full and complete can you be than that?
Well, and because it was styled as a motion to dismiss hearing, and because we believed that within the four corners of the pleadings, plus the domestic violence case, which we asked her to take judicial notice of, that was a sufficient that would have been sufficient evidentiary standard.
But I don't think that's the way. You don't present some evidence, think it's sufficient, rest on it, and if the judge says that's not enough, then say, well, okay, I lost, let's try again, give me another hearing, right? You had your shot. You chose not to put all the evidence on.
Yes, but the 6-month bright line standard is not the finality from which the court can determine that it has subject matter jurisdiction. And our argument is that she failed that the lower court failed to move beyond that to the secondary and tertiary levels of determining whether or not the court would have jurisdiction, other than based upon the
Let me walk through 61-514 and see if I get it correctly or if we agree. As I understand the process, first the trial court determines whether Florida has jurisdiction under 61-514 1 or 2, correct?
Correct.
And then, if there's a determination of jurisdiction and it's determined that another state may have jurisdiction, that's when you stay the proceedings and confer with the other state to see which state should proceed, correct?
And I think perhaps the only difference that we may have is that within that first line test is whether or not is not finitely whether or not Florida has jurisdiction, but whether Florida would have had jurisdiction to be able to...
But why would you, or legally, do you really ever get to the conferring with another state to see who should handle the case if Florida doesn't, in the first instance, have jurisdiction?
Because you have to determine if Florida and I'm backwards, so okay. In the it's our belief that this case is similar to the Hindle case in which
let me finish. So, I mean, that is the way I understand it. I mean, I don't think you ever make the inquiry to see which state should handle the case unless you first determine that Florida has jurisdiction. I mean, it just doesn't make sense that you would say, okay, we don't have jurisdiction, but we should call Louisiana to see if we should handle it anyway. I mean, that just doesn't make any sense to me whatsoever.
But part of the waterfall test there is does Florida initially have jurisdiction based upon a 6-month bright line? But if Florida
there are two ways. There's the 6-month, and you alleged in your complaint that the kid had been there for about 4 months. I mean, that's what you alleged. And I know that there's a letter somewhere in another file, but that wasn't brought to the trial judge's attention. So what the trial judge had was your complaint, which said that the child was in Florida for less than 6 months. And no other fact contrary to that was brought to the trial judge's attention, correct?
It was brought to her attention that the mother had a Florida driver's license that she had had since 2006, and that she had never, and the position was that she had never relinquished her Florida residency.
We're talking about the child. I mean, the test is whether the child is a resident of Florida or has been in Florida 6 months prior to the filing of the petition, correct?
Correct.
Okay, and then you go down to the next part. If the child wasn't in Florida for 6 months and no other state has jurisdiction, Florida can still take jurisdiction if, then there's a 1 and 2. And the 2 is that there's substantial evidence available in the state concerning the child's care, protection, training, and personal relationships. And I guess one of the problems that I have is that nowhere did you allege or proffer anything showing that that part of the test was true. So, I mean, even if you look beyond the 6-month period, there is a way for Florida to get jurisdiction if no state has jurisdiction, but you have to show that there's substantial evidence available, and I don't see that allegation in your complaint anywhere.
But equally, if no other state has jurisdiction, the Florida court has the ability to then assert jurisdiction. And again,
if it meets the 2 tests.
Yes, and the first part of
one is that one parent is in Florida. That was true. And the second is that substantial evidence is available in the state, and I don't see an allegation regarding that. I don't see an argument that applies. I don't see anything presented to the trial judge saying that you have jurisdiction because the father's in the state and because this substantial evidence test is met.
And they are conjunctive. It's not one or the other.
Yeah, it's both. For all 3 of them.
Again, we believe this case is like the Hindle case, where basically no one had jurisdiction because under Louisiana law, the Louisiana statute says that for Louisiana to continue to have jurisdiction, that both parents must reside in the state of Louisiana. And so this was a case where neither parent resided in Louisiana, where the mother had been moving between Louisiana, Florida, and Arkansas, and that there was no that the Louisiana, the case in which, or the state in which the divorce decree was granted, no longer retained jurisdiction, and so that as part of the hearing, that Florida that was capable of coming in and asserting jurisdiction under the second level test. But we continue to believe and continue to assert that there were sufficient facts that were presented to at the hearing to be able to establish that there was a dispute of fact as to where the mother was, where her residency was, and that to require the trial court, the lower court, to either dismiss the case with leave to amend, to allow us to perfect our complaint, or to be able to come in and to try and determine the appropriate
Was that
jurisdiction.
requested? I don't recall that it was. Was it requested that, okay, Judge, maybe we haven't pled this correctly, but if you grant us leave to amend, we can cure?
I don't believe that that was specifically requested at the hearing, but at the same time, the preference of the court system is to allow to a party the ability to amend and perfect its pleadings to be able to have a trial on the merits. And in this instance, by coming in and dismissing the case based upon jurisdictional issues, that created a finality within that process. And hence we took up the incident appeal.
Let me ask Ms. Schulte if she's found anything in there where you all have asked for a hearing, or an evidentiary hearing.
No, Your Honor, Mr. Buck, on page 6 and 7 is where there was a request for a stay. It was again requested for a stay at the very end of the case. There was reference to that it's limited to the four corners of the pleading. That's page 15, and that it was not an evidentiary hearing. And
That wasn't the trial court saying that, correct?
no, sir. And that's lines 22 to 23. And then the court cuts in and then references the child leaving in October.
Okay, thank you. Counsel, you've exhausted your time.
Thank you.
Thank you very much.
Thank you. If I may be excused.
Yes.